All right. Well, thank you for joining me today. We're going to be talking about the top 10 ways to stay out of court. These are some of the top 10 tips that we found based on our callers, our experience, our presentations, that sort of thing. There are things that we want to do or avoid in order to stay out of trouble. Thank you to the Monterey County Workforce Development Board as well for having us here today. Some of the services, as you know, provided, recruiting, training, or other services available. Just basically anything that you need for your business. Any questions or anything, reach out to Monterey County Workforce Development Board. They will be glad to help you out. And if you have any HR questions, hopefully they'll route you guys our way for those answers too. Contact information there, you can call it 831-755-5393 or email. I have Jerry's information on here, so make sure you give him a call with any questions, any ideas, any thoughts, or go onto the website to get some information. A little bit about me today. My name is Eli Nunez. I am from California Employers Association, and we partner with the Workforce Development Board to provide a HR hotline, as I mentioned, but any kind of HR advice. One thing we do at CEA and what we really strive for is to provide employers with peace of mind. So we offer as rapid as possible answers to human resources questions, provide training, forms, anything. Basically anything human resources related, we try to provide that so you can focus on running your business. So with that, though, one thing that we do not offer is legal advice. And even though we do have people on our team that do have a legal background, we are not lawyers, and anything we say on this presentation or any other should not be taken as legal advice, should be taken from an educational nature. I will not read the disclosure word for word because, as you know, that's the fine print. It's there for you to read afterwards. Some of the things we'll talk about today and we'll focus on our top 10 ways to stay out of court is learning how to start and then the employment relationship, right? As you know, sometimes if you start off on the wrong foot, that's going to get you in trouble down the road. Same thing happens with terminations. If you take a misstep during termination, there could be some repercussions there. You could be opening yourself up. So it's very important to learn how to start and then that employment relationship in the right way. Your policies and your handbook should be current and compliant. In California, as you know, laws change on a regular basis, right? We're in the middle of the legislative season right now. We got a lot of stuff rolling out. Some of it we're looking at really sending shivers down our spine right now. So we'll see what happens with that. But with that, make sure you keep your policies and your handbooks up to date and compliant. And as always, meal and rest period violations. These are just recurring issues with businesses, unfortunately. And it's easy to make those mistakes or oversee those things, right? Along with employee misclassifications too. So these can lead to very costly fines and repetitive fines on many occasions and open you up to other issues. So again, being compliant with those, helping to avoid those will help keep you out of trouble. And finally, addressing any harassment issues before they begin. Harassment prevention training is mandatory in the state for managers, for employees. And really the reason for that is because it opens the door to a lot of problems if you allow that to occur in your business. So, being proactive when you're addressing them, when you're preventing them, that's going to help keep you out of trouble. So with that, we'll start getting into the meat of the presentation. We have it as a countdown. So the number 10 way to stay out of court is having strong hiring practices. So at CEA, we like to say, we always want to hire slow and fire fast. We'll get to the fire part later, but let's talk about hire slow right now, right? So what that means is taking your time at the beginning. And this goes all the way back to even before you hire your employees. Knowing what you need, knowing your workforce, knowing if the position needs to be exempt or non-exempt, and if it qualifies to be exempt, if that's the case, right? You have to know what you are looking for from the beginning so you hire the right person, or at least get the right group of people in there to interview, right? Things to keep in mind, day one, whatever you do on day one, that's going to set the tone for that employment relationship, right? So that's what makes orientations so important with your new hires. One, make sure they feel welcome, but you also want to make sure that you start setting out expectations from the very beginning. What's the position? What's the job? What's the goal of the organization, right? Of course, you're going to go over policies, procedures, handbook, that sort of thing, and make sure that we are explaining those thoroughly. Now, it's not just the case where we give the new hire a pile of paper, say, read that, understand it, and show up to work tomorrow at 8. That's not enough anymore. We have to make sure that those policies are clear, they're read, they're understood, and that we're addressing any questions that come up. Okay. Of course, we want to make sure that we get a sign off on those, that the employee receives and understands those forms, as well as any other required documents for hiring. So if you're in human resources, it's exciting times for us this year. We got a brand new I-9 form, and that's about as exciting as it gets for HR right nowadays. No, make sure, you know, our forms are up to date. You know, make sure we're filling out or using the newest forms or the most recent forms, everything's correct, and make sure that they're filled out in a timely manner and correctly, right? And finally, one thing that we also are advising is building flexibility into the job as a part of the job rather than a perk, right? These last couple of years have really changed the landscape of work, which you're talking about earlier, you know. People no longer just expect to be able to have a flexible job just as a perk or as a reward, right? That's almost an expectation now. People want that flexibility. If they have the ability to work remotely, they want to be able to do that. So be open to that. I know it's difficult. It's hard to let go of the way we've done things for the past, you know, 5, 10, 20 years or something. But with the changing landscape, to stay competitive, sometimes we have to at least consider these things. So take a look at them. You know, everything's not going to work for every business, but, you know, be open to it. Take a look at it, right? Yes. Right. A lot of times what we're seeing now is there was a move towards a 4-day work week, right? And that's something that's kind of been floating around out there. People are looking at maybe doing a 4-day work week instead of a traditional 5-day work week where, you know, you kind of flex when people come into the office or not. Again, not going to work for every business, but something people are looking at. Flexible start times too. You know, you'd say where it used to be, you know, you have to be in the office at 8 o'clock and be there until 5 o'clock or what have you. People are saying, well, you know, the first meeting is not till 10, so you can be in here anytime between this time and that time, and just make sure you work your hours for the day or what have you, right? So looking at alternative work schedules, looking at alternatives to work. From a personal example, I mean, our organization downsized our office space. And if any of you are in Sacramento in October, we're going to have an open house there, so we'll make sure out to you guys. But it went from the point where we had a office space with I think it was 7 offices before to now we have an office space with 2 offices in it. So no privacy, but it's, you know, it's reflects the hybrid nature of our work. So that just kind of, it's something that worked for us. So just kind of look to see what you can offer the organization, whether it's attendance, you know, whether it's hours, whether it's days of work. That sort of flexibility is something that a lot of candidates are looking for now. You know, I hate making generalizations about generations, but the new generation is kind of expecting to have that more flexible work schedule, that more flexible workspace, as opposed to some of us more traditionally minded generations. So I mentioned hiring slow as well. Obviously, y'all taking your time to know what you're hiring, right? And sometimes we get caught up in almost a cycle, right? Somebody leaves, and we figure we better replace them with somebody exactly the same. It's the exact same position, you know, do the same work that's been done that way for the last 10, 20, 30 years or whatever. Well, sometimes it makes sense to analyze the position, analyze the responsibilities, right? Can some of that be distributed to other departments or to other people? Do we need the exact same thing again? Do we need a full-time person, or can this be done by a part-time person? Or can it even be, you know, delegated outside the organization? So take a look at that as well. To make sure that, you know, we're not just filling in a gap for the sake of filling it in, right? It may not be necessary, or it may be looking to get somebody completely different that's going to help us expand and grow into a different area. And again, you know, having somebody work with you, it's a relationship. So get to know people, right? Get to know what you need before you jump into it. Of course, when we were hiring, I always like to point out some potential problematic questions, interview landmines for hiring new people, right? It's not always the HR department that's doing the interviewing, or, you know, the hiring manager. Sometimes that's delegated out to supervisors, leads, other people participate in these interview processes. So it's important to make sure that they are trained on it, that they have some kind of guideline as to what they should stay away from, right? So the general ones, questions about age, family status, protected classes, that sort of thing, salary history, criminal history. There's some changes coming up this year to the ban the box. So keep your eyes on our website. We do have a presentation coming up on that by one of our background check companies. That's a partner of ours, but there are some changes coming up to that. So a story I always like to tell about this too is I was working for a software company. We were interviewing a software engineer. Nice young lady walks in for her interview, visibly pregnant. They do the interview, everything goes fine. As the manager's walking around, makes a comment, "Oh, is this your first child?" "Oh no, I got 2 more kids at home." "Okay." This just talking on the way to the elevator. Take the elevator down. "Well, good luck. Good luck with your pregnancy. Carry on." They decided not to hire her because they didn't think she was qualified for the job. She came back and claimed that she was not hired because she was pregnant. Was that the case? We looked at the interview notes and decided that yes, she wasn't qualified. She didn't have the experience we needed. However, because the hiring manager made that comment to her on the way out the door, our lawyers advised us that we'd better pay out on that one to make it go away. So again, train your interviewers, train your supervisors, your hiring managers. And that seems innocent, right? It's just innocent conversation, talking about family. But it came back and bit us. So be very careful with those topics. Number 9, leave of absence laws, California's leave laws, which we have a couple of them, over 20 of them actually, covering different things, right? Depending on, and it all depends on how many employees you have, could depend on what industry you are, could even depend on where your business is at. So I think it was the city of Oakland just ended their COVID paid sick leave in June, I believe it was, even though the rest of the state ended it, earlier in the year or at the end of last year. So, be aware of all those leave laws, right? And also how they interact with each other. For instance, pregnancy disability and California Family Rights Act, they cannot run at the same time. Although pregnancy disability and FMLA can. So there's some overlap sometimes, there's some that don't overlap. Be aware of those, be aware of how they interact with each other, when people qualify for them, and when you should deduct them and when you should, right? Of course, paid sick leave covers the whole state of California now. We don't have COVID sick leave to worry about anymore. Back, knock on wood on that one. But paid sick leave is something that we still see is troubling some employers. And we still get a lot of calls on it on our hotline too. A lot of employers tell us, "Oh, well, we want to pay them sick leave, but they have to turn in the doctor's note first." Don't do that. Always advise, do not require a doctor's note for paid sick leave, right? Why? You may be getting more information that you bargained for. You may be getting some information that you probably shouldn't be seeing, and that can be problematic for you down the road. So I always recommend, if an employee has sick leave available and they ask for sick leave, let them take the sick leave. A doctor's note. So not necessarily. The state requires that minimum of 3 days of paid sick leave. So as long as you're designated 3 days of paid sick leave and you're awarding those without any kind of doctor's note or anything, you're fine. Again, though, for a doctor's note, we're always leery of it, and we always tell any caller, we be aware when you're asking for doctor's note, you may be getting more information than you bargained for. Sure, if they want to do that, then hey, so be it. Their thing is, if you get a doctor's note and it shows something that maybe points towards a chronic situation or something, at that point it could trigger CFRA or FMLA leave. And if you don't do that immediately, or you do something that maybe deny them a holiday or something, they could come back and say, well, technically that leave should have qualified for FMLA or CFRA, and you penalize them by not paying them the holiday, so you violated their rights. Exactly. It could trigger different things. So it's kind of a double-edged sword in that regard.
Interesting to say that, because Monterey County requires the doctor's note.
For any kind of absence or anything?
That's
Yeah.
really interesting. They actually require the doctor's note to
Yeah.
come back to work.
Well, if you've been off of work, if your doctor took you off of work, then you can ask for a doctor's note to come back, like a release.
Okay.
But if it's just a regular absence where you say, hey, I'm calling out sick, you know,
When I worked before the hospital, they required if you were gone more than 3 days.
more than 3 days,
The hospital required the employee to provide a doctor's note.
right?
Because it was kind of a trust thing. I mean, if you were absent, if that employee had a lot of absences,
Mhm.
because it had quite an impact on
Sure,
the department.
sure. You run lean, and if someone's absent, then other people have to really pick up the slack, or yeah,
Right, and so it was prior to disciplinary action in a sense.
hmm
And so then what would happen is then you'd say, well, you need a doctor's note to come back.
right, right. And the thing is, like I said, if they have those 3 days or whatever of paid sick leave available, that really is up to their discretion to use them. And we can't really penalize them for using them or prevent them from using them. So if someone has, I have my 3 days of sick leave and I'm absent for 3 days, and you tell me, well, you have to bring me a doctor's note to come back. Like, well, I had these 3 state mandated sick days available, and you're telling me that I need this extra hoop to jump, to jump through to come back.
Yeah,
That's
good
that's
point.
beyond what the state requires and beyond what the state requests. So be very careful with requesting doctor's notes. A lot of times when people call us, about doing stuff like that, it's because people are abusing paid sick leave, right? I mean, it's, football season, so a lot of people get sick on Mondays nowadays.
The employer is kind of at the end of their rope with that employee.
Yeah.
And so, I mean, that's kind of what happens. The
Yeah.
employer doesn't know what to do.
Right.
And so they felt, like, oh, okay, I've
That
got
was their-
this.
Yeah, I mean, once somebody runs out of paid sick leave, like if you only award 3 days or 5 days or what have you, and there's still absences, you're going to ask the question, you're going to see if there's any kind of protected leave available. If there's not, it's absence. And it's terrible to say, that you're going to start penalizing people being absent for being sick, but there are limits to those sick times, and we can set limits on how many sick times we grant, right? So it's a tough one. It's a tough one. So again, be aware of the California minimum requirements, 3 days or 24 hours, and whether you do an accrual or a lump sum award. Accrual has to be at least 1 hour accrued for every 30 hours worked. Lump sum, you can do one time a year, whether it's at the end of the year, on their anniversary, at the end of the year, whatever it is, as long as it's one set time. Keep in mind though, if you are doing accrual, you have to allow them to carry that time over into the next year. If you're doing lump sum, you can zero it out and start over from scratch because you're giving the full sum right from the beginning. And of course, sick time is not paid out at termination. However, if you combine your sick and vacation time into one PTO bucket, you're in for it then, because the protections of sick time apply to it and the protections of vacation time apply to it. So then you do have to pay whatever's in that PTO bucket out. So be very aware of that. So when people call us and tell us that they want to combine sick and vacation to one bucket, first you cringe a little bit, and then we tell them, okay, you can do whatever you want, but here's some things to look at. All these protections apply. It blurs a lot of those lines, and it makes it difficult to distinguish people. So be very aware of that. And of course, be aware of local ordinances, right? So some cities, looking at you, San Francisco, require maybe.
Continuing with our countdown, we come to way number 8 to stay out of court, and that's making sure that your exempt employees are really exempt. Now, misclassifying employees can be a very, very costly mistake in the state of California. And here are some examples. For instance, Farmers Insurance misclassified 2,400 claims adjusters as exempt rather than non-exempt, which they truly were. And when all was said and done, it ended up being a $90 million mistake for them. Another example, Long's Drugs, same thing, $11 million agreement for overtime wages for store managers and assistant managers. In other words, they assumed that just because somebody had the job title of manager, that they would be exempt employees. Not always the case, as we'll discuss. It's not just about the job title. And finally, Taco Bell, even the fast food industry is not exempt from this, right? Not exempt from making these mistakes. Basically, they had some overtime violations for employees in California and Washington. and ended up with fine settlements and everything paying out to the tune of $12 million, which explains for the increase in their value menu, right? Got to pay for those mistakes, unfortunately. So again, be very careful with making sure your exempt employees are very exempt. Federal Wage and Hour Division enforcement has increased on this in the last couple of years because it's one of those things that has become low-hanging fruit, right? Very easy to think sometimes that we're going to make somebody exempt or salaried, and maybe they shouldn't have been. So take a good look at that. Now, some things to keep in mind for your exempt employees, of course, many times we think that just someone that's a manager is obviously exempt or a professional, right? And the thing to keep in mind is that in order for an employee to be exempt in the state of California, they must pass two tests, right? One is the duties test and the other is the salary test. Now, the duties test means that the majority of their work must be spent in exempt work or in exempt duties. And for the salary, of course, it must be 2 times the state minimum wage. So it's 2 times 2,080 hours times the state minimum wage is how you come up with that figure. Exempt employees, of course, we're not paying them by the hour. We're not paying for the time spent working. We're actually paying them for the skill, the knowledge, the training that they bring to the job. And of course, some of these exemptions or some of the requirements may vary based on your industry. So be familiar with your wage order. Take a good look at it to make sure what rules apply to you. And of course, some of the common exempt categories, we talk about white collar, we think about executives, right? Your CEOs, your managers. The managerial exemption, that's what gets people in trouble sometimes. We think that, people that manage other people are automatically exempt employees. So we'll talk about that in a bit. There's administrative. So for instance, think HR generalists or something like that, right? The work relates to management policies or general business operations. And that's where the majority of the time is spent. Or there's also professionals. Think of doctors, lawyers, that sort of thing. People that need licensing and or a degree in order to perform that work. As I alluded to before, thing to keep in mind, and the thing that gets some companies in trouble sometimes is that the majority of the time must be spent performing those exempt duties. So for example, I'll give you example in a production setting, right? If you have a production or manufacturing facility and you promote somebody to a foreman or a supervisor and make them exempt. However, if they are working with the hourly employees side by side on the production line, doing the exact same job that they are for more than half of their time, then they are not truly exempt employees. So they have to engage in exempt duties, think management, hiring, interviewing, terminating, performance management, that sort of thing, at least over 50% of their time in order for them to qualify for that exemption. As far as the wage test that I mentioned, 2 times the minimum wage. Of course, right now the minimum wage in California is $15.50. So that equates to if you double that for a year, that equates to a minimum of $64,480. However, keep in mind that minimum wage is going up in 2024, right? That same law basically that triggered the last increase to $15.50 is still in place. Inflation is still somewhat higher than we'd like to see it. So there's a 3.5% increase or so starting in 2024. So hourly wages will go up. The minimum wage will go up to $16 per hour, which in turn causes a domino effect, increasing the exempt minimum wage to go up to $66,560. Now, this can be troublesome if you have somebody that's in a position, again, lead, supervisor, manager, somebody that's exempt, that's right around that $65,000 range. You're looking at another increase for the start of next year, right? And, a couple options there. You can take the increase, make sure they maintain their exemption, or you can change them back to non-exempt status, right? They keep their duties, they keep their job title. They are just non-exempt at that point, which is easier in the state of California because in California, most employees default to non-exempt anyways, right? Unless you can prove that exemption. But where it gets troublesome and where you have to do some thinking too is, a lot of times you think, well, I'll just make him non-exempt and it'll be fine. I'll pay him the same. But once you make somebody non-exempt, you have to figure there could be overtime pay involved. There could be, you have to account for meal and rest breaks. And if you don't allow them to take them or they're not able to take them, you could be looking at penalties. So at the end of the day, just to save a few, $100 or so, you could end up paying more than that. So again, now's the time to start taking a look at those non-exempt employees that are right at the cusp and start making decisions and figuring to see what the best course of action is for your organization. All right, moving the countdown along to number 7. We talked about exempt employees. Now let's talk about non-exempt employees in California and what we can look out for there to avoid getting in trouble there. So of course, keep in mind any wage and hour claims in California can go back as far as 3 years. That's a 3-year look back period. And that's why it's, when you look at these settlements for exempt and non-exempt employees that were incorrectly classified, that's why those dollar amounts can be so high, because you're looking back 3 years. It's 3 years worth of penalties, 3 years worth of overtime, missed meal and break periods, missed hours, penalties, that sort of thing. So that's why it adds up so quickly. Thing about non-exempt employees too, have to be sure that we are tracking their time, right? We're paying them by the hour, so you have to track it somehow. So very important to remember, rounding in the state of California can get you in trouble. And the past year or two, we saw, a big move and a big warning came out to not round meal periods. Speaking of meal and rest period, that's the next bullet point, right? Meal period can get you in trouble as well for a very simple reason. Say, for example, meal break is from 12 to 12:30. Fine, right? It's a 30-minute break, looks compliant. However, the person goes in and clocks out at 12 o'clock with 15 seconds, and then clocks back in at 12:30 on the dot. That's not truly a 30-minute meal break. That's a 29-minute, 45-second meal break. So technically, they are not taking the full half hour being allowed to, and it would not be compliant. So again, rounding, be very careful. Do not round meal periods. We recommend, if you have the ability to pay to the minute, do not round at all if possible, right? A little more cumbersome when you're figuring out, those fractions of an hour, what have you, but if you have a good payroll system, that is going to take care of you, okay? Overtime, of course, know the rates and when they kick in. A wage statement, knowing what should be an employee's wage statement to stay compliant. We've all heard about the PAGA claims, the boogeyman of PAGA in the state of California. Wage statements are some of the easiest ways to get in trouble there. If something is missing on your wage statement, something is not included that should be, that opens the door, right, to start looking at other things. All of a sudden, they're asking for payroll records, they're asking for employee records, meal and break periods, that sort of thing. That opens the door. So make sure your wage statements are correct. Defining your work day and your work week, also very important. Now, there are defaults in the state of California. So if you don't define the work day, the presumption is that it starts at 11:59. I'm sorry, that it ends at 11:59 p.m. and starts at midnight, right? So traditional calendar day, if you will. That gets a little complicated if you have an overnight shift, right? Because the shift could be split right down the middle of the 2 different work days. So take a look at your specific organization, see what makes sense, and define it. Define it in the handbook, define it in your policies, make sure it is clearly defined and that payroll is aware of it. The other one is the work week, right? A work week is defined as any consecutive 7 days starting on the same calendar day each week. So the presumption or the default in the state, of course, is the calendar week, Sunday through Saturday, right? Of course, you may be asking yourself, well, why are we talking about this? Why is this important? Well, a lot of times people bring up that, especially employees say, hey, if I work 7 days in a row, you have to pay me double time on my 7th day. Okay, well, that's somewhat correct information, right? What they miss is that if you have to work 7 consecutive days in a row in the same work week, not 7 calendar days in a row, 7 work week days in a row. So if your work week runs from Sunday through Saturday, and you have somebody work from Monday all the way to the next Monday, technically they're only working 6 days in one work week and 2 days in the next. Even though it's 8 days in a row, there is not 7 days in the same work week. So that doesn't automatically trigger that extra overtime, extra pay for the 7th day and so on. So again, a little confusing. Give us a call if you have any questions about it. But again, make sure we're defining what our work week is, either in our handbook, policies, or what have you. Same place we define what the work week is. Rest breaks, of course, and meals. Another thing we got a lot of questions on, how many rest breaks should I be giving my people? How many rest breaks are my employees do? Really handy chart here. If you have somebody that only works 3.5 hours or less, no rest breaks, right? You have to give one. Anything above that up to 6 hours, one rest break is mandatory in there, right? See the chart, we won't go through it step by step. Thing to keep in mind too is, as an employer, our responsibility is to authorize and permit that work break, right? We're not the break police. We're not going to go around making sure everybody's stopped, sitting down, drinking water, resting, or what have you. Maybe we should, but that is not our duty. So our only duty is to make sure that we are permitting people to take that break. In other words, we're stopping work, we're taking all responsibility off of them so they can take that break, right? Another thing that's gotten people in trouble in the past too is, not allowing people to leave the job site. A lot of times we say, it doesn't make sense. The nearest store is, 5 minutes away. It's only a 10-minute break. What are they going to do in 10 minutes? Why are they leaving? Doesn't matter. We have to relinquish all control over our employees during those rest and meal breaks. So if someone decides they want to go out and drive around the block for 9.5 minutes and come back and get there at their workstation at the 10th minute, that is their prerogative. We cannot control that, right? So again, make sure that we're authorizing and permitting people to take those breaks. We're giving them the ability to take the breaks. If they choose not to do it, that's on them. But hopefully we have a way to document that, and people are acknowledging that, yes, I was given the ability to take my rest breaks and my meal breaks. Same thing with meal breaks too. Again, we're relieving people of all job duties. Okay, letting people basically walk away from what they're doing. That doesn't mean, hey, take your lunch, but stay at the front desk and answer phones. No, we're not relinquishing all job duties at that point. That is still working time at that point. If you're in the position where people have to, remove a lot of safety gear, put on a lot of safety gear for their jobs, that should be on the clock, right? That should not count against them for their meal period. So make sure that we're keeping track of that thing. As far as how many meal periods are allowed, of course, say if anybody works less than 5 hours, no need for a meal period. Anywhere from 5 up to 10 hours, we're allowing one meal period at that point. Beyond 10, they're allowed that second meal period, right? Or they should have that second meal period. Now, a lot of people say, well, can they waive that second one? Yes, as long as they're working less than 12 hours. If they're working more than 12 hours, make sure they're taking that second meal period, right? A lot of time, if you're in the position where, you don't know if it's going to be 11 hours, 11 and a half, 12 or 13 hours, you may be better off taking that second meal break just in case. You don't want to risk it. Now, something else that plays into this too is the local minimum wages, right? Here in Monterey County, even though, we're very close to the Bay Area, and there's other places around us with different minimum wages. Emeryville comes to mind, San Francisco, a couple of areas are Oakland. So be aware of what the minimum wage is, where the work is being performed. So if you have remote employees that are physically working from home and that's their workplace, make sure that we're paying them correctly, right? And this could affect other things too. This could affect sick time allotment or how much sick time they can carry over, that sort of thing. So be aware of where your employees' workplace is. Another one that comes to mind is, for instance, landscape companies. If you're a landscape company based in Salinas, but you have employees that go into other areas that have a higher minimum wage, perhaps, be aware of what that is, because we're looking to see where the work is being performed. We have a bit.ly here you can follow if you want to see. Have a page with that lists all the state of California minimum wages throughout the different areas. Now, another thing to keep that I should mention too is that the local minimum wage has no effect on the exempt minimum wage. We talked earlier about the exempt minimum wage being 2 times the non-exempt minimum wage or the state minimum wage. That is completely ruled by the state minimum wage, not by local minimum wages. So daily overtime too, another thing that can sometimes trip us up a little bit, right? So real handy chart here, real handy way to look at it. We're paying 1.5 hours of the regular rate of pay for any time worked over 8 hours in a workday, right? Or 40 hours in a work week. So if you have somebody that works 6 hours a day, they work 7 days a week, that's 42 hours for the week, so there'd be 2 hours of overtime. Now this is where we come up to that 7th consecutive day in the work week though, right? If someone works from from Sunday through Saturday, and that's when the work week runs, that's Saturday, that 7th consecutive day in the work week, the first 8 hours of that are going to be all overtime. So again, very important to define what your work week is and to be familiar with it. Double time or double pay, that kicks in after 12 hours in the workday or after 8 hours on that 7th consecutive workday in the work week, right? And very important to remember, your overtime pay, that's based on your regular rate of pay, not your hourly rate of pay. What's the difference, Eli? What's the difference between regular rate of pay and hourly rate of pay? Well, regular rate of pay takes into account things like non-discretionary bonuses. So if you have an attendance bonus or, performance goals that people hit to get a bonus, that can all be factored into the regular rate of pay. So, if you have any sort of thing like that, whether it's non-discretionary bonuses or, attendance bonuses, performance bonuses, that sort of thing, talk to your payroll person, your payroll provider, make sure that if they need to, they're taking those into account to calculate regular rate of pay, because that dictates what you're going to pay for overtime, what you're going to pay for paid sick leave, and other things. So become familiar with that regular rate of pay. As far as your accurate wage statement, here's a good example of what should be in one, right? We'll go over some of the basic things. The name and address of the legal entity, that's the employer. It's name and address of your company or yourself if you're a private employer. Some kind of identification number for the employee, either social security or an employee ID. We want to make sure that that is on all of them. We're going to account for all hours worked on there and all rates of pay as well. And we have to show all the deductions, federal taxes, any kind of medical insurance if we take that out, that sort of thing. Going to show gross wages and net wages. And then very important, if your employees have paid sick leave, vacation, PTO, whatever it is, that sort of thing, make sure that we're showing that balance on that pay statement. Now, if your pay statement or your wage statement does not have the balance on there, you can provide that on a separate statement, print up a separate sheet or, another separate report or something that you give them when you give them this wage statement, you make it available to them. People ask us, well, can't they just look it up online? Yes, they can look it up online, but you have to give them the ability to be able to print that up. So what we recommend is if you have a virtual, payroll system where people can look up their wage statements, make sure you set up a kiosk, a computer, a printer, or something in the break room or in the office where they can print up those wage statements for themselves. Otherwise, stay out of trouble, just print them up yourself. As far as paid sick leave or vacation or that sort of thing showing up, talk to your payroll provider if you use one. They should be able to incorporate that into your pay statement. All right, enough about, hey, let's talk about number 6. Independent contractors. A very complicated thing in the state, right? More complicated than it should be, maybe? I don't know, but for a long time in the state of California, we followed more or less the federal guidelines, which I believe was the Varela rule, as far as determining if somebody was an independent contractor, right? State came back a few years back and said, well, that's not really clear enough. So we want to be a little more clear as to what constitutes an independent contractor. So in order for somebody in the state to be considered an independent contractor, they have to meet all 3 of these requirements, the ABC test, right? They have to be free from the control and direction of the hirer. In other words, say, for example, here at the Workforce Development Board, if we hire somebody to come in and do some IT work for us, they're going to run some cabling or something, right? They're going to come in, we're hiring them for their expertise, and we're just going to contract them saying, this is the job we need done. However you guys do it, do your thing. We're not going to manage you, every step of the way. We're not going to micromanage you. We're not going to tell you how to do the job. We're hiring you for your expertise, for your knowledge, for your trade. Just come apply your trade, okay? Their thing is the work has to be outside the usual course of the hiring entity's business. So for a long time, some companies get away with saying, well, we need some temp assistants. We need some temps to do because, we got this huge order and we need more people on the production line. So we're going to bring in 20 people, but they're going to be independent contractors. And we're going to pay them a set amount and they're going to work side by side with everybody else. That work is not outside the usual course of business, right? They're doing exactly what your other employees are. So that would disqualify them from being independent contractors. And finally, the person has to be engaged in a trade, occupation, or business of the same nature as the work performed. So again, there's no situation where the title doesn't dictate whether they're an independent contractor or not, right? If you hire a plumber, you have to come in and do plumbing work. So if I'm like an electrical contractor and I need an extra set of hands to do some unusual work, and I hire somebody and say, well, they're a plumber, they're a plumber, so I'm going to hire them as an independent contractor, but they're doing the same work as all my other workers do. They're not engaged in the trade or occupation that their job title means. So again, make sure if you're going to hire an independent contractor, they meet all three of these requirements to make sure they truly fit that classification. Otherwise, they could be an employee. And of course, with employee comes those responsibilities like possibly overtime, meal breaks, bring on payroll, all that thing. So if you have any doubts, any questions, you give us a call. But we always say if you have any doubts about a situation, whether it's something that you're planning to do or something that you've already done, maybe talk to legal counsel just to assess what your exposure, your risk is in that situation. Okay, moving on to number 5, preventing and promptly correcting harassment. The state of California, if you've done harassment training with us, or actually most places talk about this, the state of California believes in something called knew or should have known. In other words, if they believe that your organization knew or should have known something was going on, the organization is going to be in trouble, right? So in order to prevent harassment, of course, we have mandatory harassment prevention training. That's for all employees and supervisors in your workplace, right? Want to promote professionalism in the workplace. And keep in mind too, harassment, it's not just, we don't just have to be careful with it, from 9 to 5 or whatever our work hours are, right? It's not a matter where we punch out of the clock and we're free to do whatever we want, because what we do outside of work has effects on our workplace as well, right? So for instance, if you go out with coworkers after work and something happens, that's going to affect the workplace. If you're traveling with a coworker, something happens, that's going to affect the workplace, right? So harassment can occur anytime, anywhere, on the clock, off the clock, at work, off work, whatever it is. So, some of the best defenses we have there is making sure that you have communication culture, is what we call it, right? The open door policy. Employees have a place to report these things, to talk about it. They can come to management, human resources, their supervisor, their lead, whoever. They could come out and they have somebody to talk to about these issues should they arise. So again, make sure you have a policy in place that outlines what the complaint process is. Make sure people are clear on that and know how to report that. Okay. Talk about training requirements too. In the state of California, mandates that any business with 5 or more employees has to provide harassment training every 2 years. Every 2 years. So, and of course, regular employees or day-to-day employees have 1 hour of training. Anybody that's in a supervisory position is required to have 2 hours of training. The definition of supervisor, again, it's not just a job title. It's anybody that oversees any workers, directs the work of any workers. So it doesn't matter what the title is. If you're in that position, you may have to take that 2-hour class. New hires, newly promoted supervisors, if they need additional training or they have to get training, should be done within 6 months. So we recommend if you're hiring on new people, make it part of the orientation process. Set 1 hour aside for those new hires, or 2 hours if they're in the supervisory position, to make sure you're getting that training requirement out of the way. And of course, seasonal and temporary workers, which I know in this region, there's a lot of industries that use a lot of temporary or seasonal labor, right? So you might think, well, if it's 6 months and the season only lasts 3 or 4 months, I don't have to worry about training. No, unfortunately, that is not the case. The state was aware of that and put in the rule that if you have any seasonal or temporary employees or someone that you're going to hire less than 6 months, they must be trained within 30 calendar days or 100 hours work, whichever occurs first. And we know that in some industries, that 100 hours, that could happen really quickly, 2 days, or 2 weeks, 3 weeks, and they'll hit that 100 hours very quickly. So be aware of these requirements, have a good training partner available so you can take care of this. Now, speaking of training, I always talk about your managers being your first line of defense, right? So they're the ones with their ears to the ground. They're the ones dealing with employees day to day. They're the ones that are going to hear about any of these complaints. So make sure that you're training them. Make sure you're getting them on board, because honestly, management is going to set the example for the team, right? I have kids myself. As much as I like to say, do as I say, not as I do. That's not how it works. People are always watching. They're going to do what you do. Whatever example you set, that is what's going to follow. So again, train your employees, your frontline supervisors, your managers. Make sure they know they're the ones in charge, they're the ones setting the pace, and make sure they know when to escalate any issues, make sure you know how to enforce policies, and make sure they know who to go to if they're not sure. I'd rather have a manager or supervisor ask me 20 questions than try to wing something, try to wing it and get us in trouble. So yeah. Training to de-escalate things, treat employees with respect, and make sure that they're addressing those issues as they come along. Now, this slide we always love because it shows you when you should start looking into harassment, or any other issues in the workplace, right? A few other triggers to look at. So talked about knew or should have known. So what's that mean? Well, if you have a foreman or a leader or supervisor, and they become aware that something's going on, some form of harassment, and do nothing about it, you can't just say as a CEO or as an owner, well, they never told me, so, I'm not responsible, that's on them. Unfortunately, that's not how the state sees it. The state sees it as if that lead, if that foreman, if that supervisor knew about it, they as your agent had the responsibility to inform you. And in the eyes of the state, if they knew, the organization knew. So you should have done something about it. Be very careful. That again, partner with your frontline managers, supervisors. They're your first line in this case. The other one's suspicion. If you suspect something's going on, look into it. Follow your gut at this point, right? Ask the question. Could be nothing, but maybe you're getting ahead of things. So again, if you have any kind of suspicion, look into it. If you observe any conduct, obviously you want to do something about it. You want to address it. And this is something that we want to, again, drill down to our managers, supervisors, frontline people, right? If you see something, do something, say something, report it, step in and change it, right? If you ignore something for the sake of production or productivity, it's going to cause a huge issue. Because remember, when they saw it, when they observed it, they knew, and you as an organization knew or should have known about it, right? You receive any complaints, of course, whether they're written, verbal, anonymous, that note slid under the door, that's a trigger. We have to do something there. Any administrative alerts. So this is where we get those unfortunate letters that I think most of us have gotten as HR professionals, where it's a letter from a attorney's office asking us for a copy of an employee's file, or we get a letter from the state saying that there's been a complaint lodged or anything like that. At that point, you kind of take a step back, you sigh, but you have to look into it, right? Maybe it's a little, you might think it's a little late. It's not. It's still a good chance to look into it, start investigating what's going on, what happened, how can we correct it. Any unexplained changes in the workplace? Example I always give is you have a group of employees that have, always sit together at meal time or lunchtime or whatever it is, always sit around at break time. And all of a sudden you notice that one person that was with them all the time is completely across the room. They're no longer talking to them. They're no longer sitting by them. They look uncomfortable around them. What happened? Could it be harassment? Maybe. Could it be something else completely unrelated? Maybe you got, 49er fans and Raider fans in it's football season. Yeah, that could be it. But you know what? Ask the question. Look into it. Make sure that it's nothing that you have to look into. I'd rather, spend a little time finding out that it's not an issue rather than ignore it and have it come back and become a huge issue down the road. And finally, any persistent gossip or rumors, right? Is there gossip and rumors in the workplace? Absolutely. Does that mean we should ignore them? Absolutely not. That's sometimes how we get that information that we wouldn't get otherwise. So again, if you start, there's rumors, there's gossip, there's all kinds of things going around. If you start hearing them, especially if they're aimed towards specifically one person, whoa, why is this happening? Let's look into it. Let's find out what's going on, get to the bottom of it, prevent any big issues from happening. Number 4, we're getting close to the end here. Your employee handbook. I talked earlier about policies, procedures, that sort of thing. Well, your employee handbook, make sure if you have an employee handbook, make sure that we're following it, right? Make sure we're staying consistent with it. But most importantly, make sure we're keeping it up to date. Okay. Handbooks, laws in the state of California change on a yearly basis. Now, a lot of these affect our policies, which are in our handbook. And if our handbook's out of date, we could be in trouble, right? So the thing about handbooks is a lot of times it is the first thing your employees refer back to when they have a question. So again, keeping that handbook up to date, looking at it, make sure that it's relevant, make sure that's information you want your employees to have is huge. So again, make sure that handbook is up to date. Take a look at it at least once a year. Anytime there's a change in laws or anything like that, go back and see how it affects it, right? If you sign up for a newsletter, we'll put out alerts anytime there's a big change in law or anything. So if you see those coming, make sure that you're taking a look at that handbook. So speaking of those, of course, there's a big question we get is, what should be in the handbook? Well, we have some things that are required to be there, some things that we recommend, right? Required to be in there is harassment prevention. That's that statement. We don't tolerate harassment, we don't tolerate discrimination, et cetera, et cetera. You list your protected classes and that sort of thing, right? So again, the harassment prevention policy definitely should be in the handbook. Lactation accommodation policy, mandated by law, put that in the handbook. And if you're handing that out during orientation, give that to everybody. So I'm going to say about that, give it to everybody, no matter what. Age, race, gender, whatever, give that to everybody. Your FMLA/CFRA or pregnancy disability leave information, that should be in there, as well as paid sick leave, all that information, put that in there. And then some recommended things, of course, meal and rest breaks, put those in there. Overtime, if you have a vacation policy and a cap, put those in there, as well as a list of any holidays that your company observes or other leaves that qualify that your company is required to follow, right? Of course, those are going to be dictated by the size of your organization. So if you have any questions, give us a holler. Okay. Down to the top 3 here. Top 3 ways to stay out of court. I guess these can be a presentation on their own. And the first thing is insurance. I'll focus a little bit on workers' compensation, right? Of course, all employers in California should have workers' compensation insurance. And it's not just about signing up for it, getting that certificate, filing it away and calling it good. And then if somebody gets injured, you just figure, the workers' compensation carrier takes care of it, right? That's not the case. I mean, there's more to it than that. So you're paying for this insurance, you're paying for a service, you're paying for a partner, right? So get to know your carrier, get to know your local office, see what other resources they have for you. Your goal should be to prevent injuries, right? To prevent any of your employees from having to tap into that workers' compensation. Well, guess what? The insurance company, that's their goal too. Because if that's what happens, all that's happening is you're sending them that monthly or quarterly or yearly payment, and they're not paying anything out. So it's their goal that nothing happens. So they should have some resources to help you, right? Training, education, posters, whatever. Tap into that, get to know them. If you haven't gotten to know them yet and you have an injury, you know what? Call them up now. Get to know who that adjuster is on that case. Know if they have any pets, know their favorite color. Maybe not that much, but get to know them because you're going to be partnering with them to try to get that employee back to work safely, as quickly and efficiently as possible to reduce your liability, your cost, and reduce theirs. So again, know what the process is, know the resources, partner up with them. Of course, you can look at other types of insurance too, depending on your business, right? There's employment practice liability, which protects you against any claims by either current or former employees in regards to discrimination, harassment, wrongful termination, wage and hour, that sort of thing. If you're interested in that, give a call to your, usually to your workers' compensation carrier. Large companies usually offer that as well. Otherwise, if you offer benefits, talk to your insurance broker and maybe they'll give you some more information there. Let's go with our top 2. Number 2 is using effective discipline and documentation. If there's one thing and one thing only that I was going to train a new manager, supervisor, CEO, lead, whatever, on, it would be documentation. 3 words, document, 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 right? Anytime we have some kind of conversation, coaching, any kind of communication of an issue with an employee, we want to document it, right? And documentation doesn't just mean, we have that formal write-up in triplicate carbon copy form or whatever it is. Documentation can take many forms. If you coach an employee, maybe you're talking to them about their attendance because they've been absent a couple times lately or performance or what have you. You just want to talk to them about it. You go, you have that conversation with them, you make your points, and then you go right back to your desk and you follow up with an email. Say, hey, just want to thank you for taking the time to talk to me. Just wanted to, go over some of the points we talked about. We talked about your attendance, we talked about your performance, and we talked about whatever else. Thanks again for having that conversation with me. If you have any questions, please let me know. You hit send. Seems pretty innocent, right? Hey, just following up, being polite. But look a little further. What you've done is you've put a date stamp. You've documented that conversation. So if the issue arises again and you bring it up and the employer says, well, no, we never talked about it. You say, oh, well, yes, we did. And I followed up with this email, this time-stamped email. I sent it back to you at 2:55 p.m. on Friday, September 1st or whatever it was. So that in itself is documentation, and that can help us down the road, right? If you have to go a little further, a little more formal, where you're having a written warning, written documentation or anything, of course, very important to present it, state the problem, talk about what the consequences are going to be, and how it can be improved, right? Documentation is not just about telling people what they're doing wrong. It's about correcting that. It's about fixing. It's about how can we move forward from there. So make sure that we have a plan in place for that. And of course, you have to do any kind of corrective action, any kind of documentation. Make sure that we're focusing only on work factors. We're not going to write somebody that's slow and say, well, you're too old for this job. No. Because at that point, it's probably illegal, right? We've all talked about protected classes before, your age, gender, race, religion, sexual orientation, that sort of thing. Those are all protected. So if you're writing people up based on those things, we've got issues. You're in trouble, right? So again, we're only going to make any of these corrective actions, any of these decisions based on things like work performance, attendance, safety violations, violations of company policy. And these are all things that should not be a surprise. These are all things that the employer should be very familiar with, whether it's from their orientation, from receiving the policy, from receiving the handbook. These should all be things that the employee is aware of and knows that they violated those policies. And just a refresher, some protected classes, of course, as you can see, California has quite a few, like twice as much as are listed under Title VII of the federal law. So these are all California protected classes. It's important to be aware of them, right? Just to make sure that we are not in violation of state or federal law. So again, some things we can do to avoid getting in trouble. Make sure we're asking employees to focus on their work while they're at work. Okay. Encourage civility, right? No matter what the topic is. I know things have gotten very heated probably in the last, 4 to 10 years or whatever in the workplace, whether we're talking about politics, for instance. Those conversations have a way of getting really heated. Religion, that sort of thing. All those things have an opportunity to be very heated conversations. So be very, very aware of them, right? And some other things, of course, don't allow politics to be used as a cover for harassment. Certain slogans, certain phrases when directed at a specific group of people can be a form of harassment. So be very careful, of course. Any policies on the use of technology, whether it's using company computers or phones for texting, emailing, messaging, or whatever, make sure that we're enforcing those. And again, make sure that we are enforcing things consistently. If you want to basically, burn your policies and burn your own handbook to the ground, the easiest way to do that is to be inconsistent with their enforcement, right? Because if anytime that happens, you can be accused of showing favoritism or of singling somebody out, and that is a tough hill to overcome down the road. So again, be very consistent with your enforcement. Make sure that we're enforcing our policies whenever there's a legitimate violation. And of course, whenever we see a need to enforce that policy or to take any corrective action, we need to act, right? Timeliness, consistency, legitimacy, all very important for employee discipline. All right. Now, without further ado, the number one way to stay out of court. Fire fast with no surprises. This is a great bookend, right? We started with hire slow, take your time, and this is the other side of the coin, firing fast. Now, that doesn't mean that we're going to walk into the office tomorrow and just, start pointing at people. You're fired, you're fired, you're fired, like a gunslinger. Nope. What we mean by fire fast is when it's time to terminate somebody and you've got all your ducks in a row, you've gone through the process, you've reviewed, the file, reviewed the policy violation, done your investigation. When it's time to terminate somebody, you make that termination. So if you make that decision on Monday, but payroll's on Friday, and you just really don't want to cut that extra check because it's so much trouble, and you'll just wait till Friday, a lot of things can happen in those 5 days, right? That employee comes in to work and they turn around and leave and they slip and fall, guess what? Workers' compensation issue. And if you still terminate on Friday, they could say, oh, well, why are they terminating me now right after I got injured? That sounds like retaliation. Is it retaliation? Probably not. But then it's on you to prove that you've made a legitimate decision to terminate that employee. And that their injury or this latest, mishap had nothing to do with it. And unfortunately, a lot of times, perception or appearances plays a huge, huge role in what happens with these things. So we have to be very careful. And of course, no surprises, right? If we're going to terminate somebody, it should be for a policy violation. They should have been aware of that policy. They should have been aware of what the expectations were and what the consequences were. So there should be no surprises. So it's important to make sure that, we're staying engaged. Our employees are engaged. We're coaching them along the way. Some of the easy things too, when you're going to terminate somebody, some forms that are required, right? We have that DE 2320 form. That's that little blue booklet from the EDD. Make sure we're giving that out with every termination. Any insurance information or medical information, right? Whether it's the health insurance premium payment or any COBRA information, certificate of group health plan coverage, make sure we're giving those as well. And a notice to employee as to change in relationship. That's an employee action form that some people call them. One says basically, your employment ended on X date because, for performance, right? We're going to write down why the employment was ended, whether it was performance, resignation, layoff, whatever it is. We're going to write that on that change in relationship. We're going to document the action and why it happened. Okay, another way to stay out of trouble here, make sure we're paying people correctly when it's time for termination, right? And what we always say is if you're going to let somebody go, the minute that those words leave your mouth, when you say you're fired or we're letting you go, we're laying you off, we're promoting you to unemployed, whatever you want to call it, the minute those words leave your mouth, you better have that check in your hand ready to hand to them, right? So if you as an employer are initiating the action, you have to pay them at that moment. If somebody voluntarily quits and gives you more than 72 hours notice, so they tell you on Monday the last day is on Friday, you better have that check ready for them on Friday. If they gave you less than 72 hours, then you have 72 hours to pay them, right? Clock starts when they leave, when they quit, you have 72 hours to pay them that final pay, their vacation, everything in there, right? Now, thing to keep in mind too is the minute that termination happens, whether you fire somebody or whether somebody tells you they're resigning, any direct deposit agreement ends. So you have to give them a live check unless they fill a new direct deposit agreement. And if they ask for you to mail that check, make sure you get that request in writing or email or text or whatever, something you can document. Don't just mail a check on your own, on your own volition or what have you, because if that check gets lost or the dog eats it or, the neighbor takes it or the roommate throws it away, you could be on the hook for waiting time penalties, of course. So be very, very careful with that. Some other best practices, of course, if you're going to terminate somebody, I always recommend have somebody there with you, right? Don't do it alone. Always good to have a witness for that sort of thing. If somebody resigns, they come and tell you that they're resigning on a specific day, make sure you get it in writing, whether it's a written note from them or you have to fill out a form on the spot with their final day, whether they want you to mail a check, whatever it is, make sure you get it in writing because do people change their minds? Absolutely, all the time. So get that voluntary resignation in writing. We always advise, exit interviews because sometimes people aren't comfortable telling us if they have any concerns or any issues while they're employed with us. So we want to give them a chance to give us a chance to improve things, right? And of course, using a checklist helps us to make sure that we're doing everything we can. So Thank you for joining me. Again, some takeaways for you. Make sure you take a look at internal procedures for compliance. Train your supervisors and managers to ensure policies are followed. Have that open door policy. Give people a chance to help you improve things, right? Review policies with employees to make sure they're clear on them. Don't just throw a stack of paper at them. Make sure they understand what they're receiving, what they're signing, what's expected. And finally, update that employee handbook once a year. I'd like to thank the Workforce Development Board once again for letting me present to you. You have any questions for the Workforce Development Board, please give them a call. There's Jerry's number there, his phone number, email, or the website. A lot of great resources on the website, including past presentations that you can access on there. And of course, if you have any HR question for us, give us a call. Reaches Monday through Friday, 8 to 5. We take holidays off, sorry. But if you have any questions for human resources, whether it's hiring, firing, paid sick leave, breaks, employee handbooks, harassment, remote workers, whatever it is, give us a call at that 800 number. We are happy to hear from you. So from CEA, thank you very much. Appreciate your time, appreciate your attention. And I hope that you found this presentation informative. Thank you. Enjoy the rest of your day.